I'm just trying to figure out. Good morning, Ms. Lilios.
Good morning, Your Honors. My name is Loretta Lilios. I'm an Assistant District Attorney for Middlesex, and with me is Assistant District Attorney Carrie Ann Kilcoyne. The district court judge here allowed the motion to dismiss, saying that he could see no difference between the Massachusetts safe storage provision and the District of Columbia ordinance that the Supreme Court found to be violate the Second Amendment in the Heller case. And the district court judge was wrong for two reasons. First, because the D.C. ordinance at issue in the Heller case was an outright ban on handguns, making it impossible for a person to use one for the purpose of self-defense in the home. And second, he was wrong because he assumed incorrectly that the Second Amendment had been incorporated to apply to the states. Now, the Second Amendment issue really is a red herring here. We have analyzed the case as if the Second Amendment did apply to the states. That issue is squarely before the Supreme Court now.
So shouldn't we wait on that one?
I would urge the court to find that this ordinance would pass muster even under the Second Amendment for...
Now, in terms of that, in terms of what differences our law has with D.C., I gather that one difference is that in our law you are allowed to carry the gun within your home, when in D.C. you cannot, correct?
That is one of the differences. Another difference is that in Massachusetts under 131L, it's not just carrying, but if it is under the control of the lawfully authorized user, you also would not run afoul of the Massachusetts statute, whereas the D.C. ordinance banned all handguns, and the way the Heller court interpreted the ordinance, it was that any handguns in the home had to be rendered inoperable.
Okay, so the differences are that we do permit you to possess a handgun within a home, and D.C. does not.
Correct.
We permit you to carry a handgun within the home, and D.C. does not.
Correct.
We permit you to have a handgun within your custody and control within your home, and D.C. does not.
That's correct.
It seems that the D.C. law also required that the gun be unloaded. Do our laws require the gun to be unloaded when stored? I didn't see that.
No, the 131L does not suggest that it must be unloaded. It specifically says that it has to be secured in a locked container or equipped with a tamper-resistant lock or other safety device, engaged so as to make it inoperable to anyone other than the owner or lawfully authorized user, and with some of the mechanisms that are widely available and affordable today, a weapon can be made operable by the authorized user almost instantaneously.
So in Massachusetts, you could have the gun be loaded, simply secured. And in D.C., you can't even have the gun be loaded.
That's correct. And as to handguns, were under the prior ordinance, they were not able to be even registered within the district.
I take it, just to follow up on a question of Justice Gantz, that under the 131L, if the father had been home, there would be no issue here at all, correct?
I disagree with that, Your Honor. That is one why? That is one of the interpretations that the defense has set forward, that if the authorized user is under the same roof as the weapon, then that would not run afoul from the statute. But I suggest that being under the same roof and having the weapon in your control for purposes of this statute are not synonymous. The purpose of the statute is to keep the firearms out of the hands of unauthorized users.
So when you say control, you mean much more than just being in the house. In other words, it either has to be by your side or in your hand or in your view so that you can actually grab it if somebody were to come. Is that what you mean?
I do, Your Honor, and I would point to the tragic Suffolk incident where the 7-year-old gained access to a weapon and shot and killed his 8-year-old cousin. Now, there were adults right in the adjoining room there. So a construction of being under the same roof really would not get to what the heart and the purpose of this provision is, which is to protect the unauthorized users, especially children. Subsection C, D, and E of 131L specifically speak to individuals who might gain access who are under 18 years of age. And a construction such as that would promote rather than obstruct the use of a weapon for self-defense in the home. And so that is a level of control that permits the owner to deny access to the unauthorized user while at the same time maintaining the weapon in close enough proximity to him so that it can be retrieved as if he were carrying it. Now, the defense suggests...
Lilius, could I just move slightly off to ask you, sort of, standing back from this case, we know that sometime before June 26th, the United States Supreme Court, in all likelihood, will reach a decision on whether or not the Second Amendment is incorporated. Unfortunately, there are lots of these cases going on at the present time. Would it be problematic if in each of the cases we looked at them assuming that the United States Supreme Court is going to say that the Second Amendment is incorporated through the appropriate amendments to the Constitution and applicable to the states? Or is it better to stay all of those proceedings?
Well, I think in the case that you have before you now, where the defendant has
But
launched
we've got many cases before us, even today. I think we've got 3 of them.
Well,
I mean,
here
it
we
didn't
have
happen to arise in the first argument, but it's in the first case, it's in this case, it's in the next case. And believe me, we didn't have to look very far to find these cases. They're all over the place because guns are ubiquitous.
Well, the Commonwealth would ask that you decide this case as if the Second Amendment applied.
Okay.
The district courts and the trial courts could use the direction on this question. And I think just looking at the Heller case, the Supreme Court went out of its way to make clear that the right to bear arms, like all rights, is not unlimited. It can be curtailed by regulatory measures. And this court echoed that same view in the recent Weston W. Lowell curfew case. And the court in Heller went out of its way to acknowledge the legitimate police powers of a state to regulate.
What standard do we apply to the regulations? Rational basis, heightened standard, compelling circumstances? What?
It is not clear what standard the Supreme Court would apply.
If it were incorporated.
If it, correct, under the Second Amendment, it is
so
not clear.
We've got 2 levels of hurdles.
It appears from the Heller case that, from the language in the Heller case, that they would not apply to this provision a strict scrutiny review because they went out of their way to say that the Heller decision was not invalidating laws that were enacted to prevent accidents and that such regulations were presumptively lawful. And certainly with the facial challenge that you have before you in this case, there is a presumption of constitutionality in the statute. And regulations...
Should we be looking at whether or not the right of self-defense, the use of a firearm, is equivalent to what it was in 1791? Is that something that we should be attempting to apply?
Didn't Heller address that and say no?
The Commonwealth's interpretation of Heller is that it did address that and did not equate the self-defense interpretation the same way that it would be at the time of the ratification of the Constitution. But I think what is... And the incorporation is not a foregone conclusion, despite what...
No, I understand that, and I'm really not asking you to be clairvoyant. What I am trying to do is to think of what's most helpful for both the Commonwealth and defendants in this period of time. If this were the kind of case that didn't arise very often, it would make it I suppose one way to do it is to say, assume that it will be incorporated, then you get to Justice Cordy's problem, but nevertheless see if you can reach a decision. And if you can't reach a decision, in other words, if it were not incorporated, or if you applied strict scrutiny, or rational basis, whichever one, stay those cases, or that's the question here.
Well, as to this provision, it's the Commonwealth's position that it's appropriate for this court to decide the case now, and that even under a strict scrutiny standard, this provision would pass muster. This term, lawfully authorized user, it means something. It is not an empty
Lilius,
term.
I know it's very frustrating when you run out of time, but unless there's a question, because we have so many cases, I'm going to ask you to rest on your brief.
Thank you, Your Honors.
Thank you. Mr. McMahon, you've got 5 minutes.
Madam Chief Justice, and may it please the Court, Brendan McMahon on behalf of Richard Runyan. This case stands before you because of the Heller case. It was a timing issue with respect to Mr. Runyan. He was charged immediately before the Heller decision came down, and when the Heller decision came down, I read it. My reading of the Heller decision states that it seems to me that they hold two things, not just that the district court's ban, the wholesale ban on guns, is unconstitutional and violates the Second Amendment, but they go on to say, in addition to that, they have to address specifically the trigger lock provision, or the provision of the D.C. ban.
But there's a real difference in the two statutory provisions, right? I mean, the D.C. ban doesn't have a owner or authorized user exception for the trigger lock, correct?
It does allow a firearm to be in the home so long as it is rendered inoperable, which is equivalent to having a trigger lock in the Massachusetts state.
Well, but the trigger lock doesn't apply if you are the owner and you've got it in your possession or control.
In D.C.?
No, here.
The trigger lock doesn't apply if you've got it in your carrying it with you. The Commonwealth is arguing that if it is in your home and it is not essentially within a few feet of you, that you're required to have the trigger lock. And
well, but, I mean, isn't Ms. Lilios right, though? If self-defense is your issue, you better have it pretty near you. I mean, if somebody's breaking in, and if you have it pretty near you, you can use it.
I would recognize that, Your Honor. Obviously, if self-defense is the core right that you're trying to protect, having the weapon, the firearm next to you is much more convenient. But I can certainly imagine a circumstance where individuals are perpetrating a home invasion, break into the front door of the home, and the owner of a gun recognizes that the firearm is in the room next door to them, or that they are in the shower and that the firearm is in the bedroom. They certainly shouldn't be expected to bring a firearm into the shower so that they can protect their
well, in my view, they shouldn't have a gun in there at all, but that's not, I'm not the...
Unfortunately, Heller doesn't stand for that
I
proposition, Your Honor.
appreciate that fact.
Now, is it your position that that the law should be the state of self-defense in 1791, that we should be looking at trying to make sure that we don't diminish the right of self-defense or the use of a firearm below that which was available in 1791?
I would agree that with Ms. Lilios that the Heller court, in fact, addressed that. But what they said, what Justice Scalia says, is that although in the context of 1791, the right to bear arms, it was those arms that are in the usual course of an individual owner. And they specifically indicate that under today's standards, a rifle or a firearm, a conventional weapon that would be used, a firearm or, excuse me, a pistol or a rifle that would be typically found in the home would be what we would look at. Justice Scalia actually references weapons such as the M16 that would be typically used in the context of an army or a military.
But I guess my question is,
as not applicable to
pragmatically, in 1791, someone's breaking into your house. How long does it take before you can grab your musket and fire it?
Having never fired a musket, I'm not sure, but
Well, I mean, I
suspect that if it's loaded and ready to go, and there's nothing preventing it from being fired, for instance, a lock on it, it would be much quicker than if there were a lock
Okay,
on
but
it.
I mean, I'm from Lexington, so we see muskets all the time, and I think in the dissent of Justice Breyer, he says, I think it's on the Minuteman Trail, 20 seconds to load and fire a musket by a trained British grenadier. You can, under our law, you can unlock a secured container and be ready to fire within 3 seconds. Why is this below the level that was available in 1791 in terms of the ability of a person to defend themselves with the use of a firearm?
Because in Heller, Justice Scalia specifically addresses the trigger locks, and on page 2818 specifically states that under that provision of the D.C. law that requires a trigger lock to render the firearm inoperable, that is unconstitutional.
Okay, but in D.C. you can't have it. It can't be loaded either. So you'd have to pull it out of the trigger lock, then load it, then fire. Here, it can be loaded.
I understand that, Your Honor, but what I'm trying to get at is all of those arguments about whether or not it's loaded and whether or not it's in the house, he places those aside, and specifically on page
Well, the
2818
language he uses is kept inoperable.
Correct.
So the question is kept inoperable. I mean, in light of his later language about, there's no reason why you can't have safety regulations and so on. I mean, kept inoperable seems to me has to be read in the context of the D.C. Circuit's severe restriction.
Well, except that he references that after discussing the prior portion of disassembled or kept inoperable with a locking device. So he's gone through the first portion where...
No, I know, but if you look at the D.C. Code, it's unloaded and disassembled or bound by or similar device unless it is kept, I mean, it's a whole bunch. I mean, the D.C. Code is not, it's inoperable.
Correct. But what I would suggest is that portion on page 2818 does address the disjunctive portion of the D.C. Code that specifically applies to the inoperable by reason of the lock.
But it's also inoperable by reason of unloaded and disassembled.
Correct.
Or, I mean, he's looking at the whole thing. They're saying make it inoperable.
Right.
And included within the D.C. reg is the little thing trigger lock.
Right, and I think that portion of his decision on page 2818 is, if carefully read, he's gone through the overall inoperable and then gets to what is, I think, applicable to this case, the trigger lock.
Mm-hmm. Thank you.
Thank you.
Mr. George?
Morning, Your Honors.
Good morning.
Specifically in the Heller decision, just to refer back to Your Honor's question, on page 58 of the Court of the Opinion District of Columbia versus Heller.
On page, you're now on the United States Supreme Court official reports.
I'm sorry, Your Honor.
Page 58?
I believe it is, yes.
Okay, I've only got unfortunately my copy's only got the
And
unofficial report.
I think this may be out of the Westlaw or
Yeah.
Aspen law, Westlaw, actually,
Sure.
Your Honor.
Okay.
He says, the judge, the opinion says, apart from his challenge to the handgun ban and the trigger lock requirement, respondent asked the District of Court to enjoin petitioners for enforcing the separate licensing requirement in such manner as to forbid the carrying of a firearm within one's own home or possessed land without a license. And I believe that the gravamen of the Heller decision is to say that, in particular, there is a constitutional right to defense within one's home, and that right has been historically enshrined in the laws of most of the states in their own constitutions, aside from the Second Amendment to the United States Constitution. It's not in our Constitution specifically stated as a right, but it is, I think, in 34 different states. I think that the question of the applicability of Section 131L to this particular case is a question of whether or not, and raises the question of whether or not, in the home, a lawful owner of a gun, a handgun, and I would submit to you as a subset of that, a rifle such as was involved in this case, which was a hunting rifle, and therefore still even in Massachusetts, a gun that's commonly used, in common use and in common possession in the home. The question is raised as to whether or not those items need to be trigger locked when in fact there is an adult family member in the home. And I submit to you that
Well, that's
section...
not raised in this case, is it? Because he
I'm
wasn't.
sorry, Your Honor.
Well, the adult family member wasn't at home.
There was
Are you saying that Alexander?
Runyan,
So you're
who was
saying that he
18
was?
years of age.
Okay.
Wasn't he the young man who was shooting the BB
Yes,
gun?
that's right.
He was shooting a BB gun,
Because he
And-
was angry with his neighbor.
and he said he was angry with his neighbor.
And he had two other rifles under a bed there.
He didn't have them. His father had them.
They were there in the house
They
with
were.
him.
They
and
were,
he
Your
was the
Honor.
only person in the house.
They were, Your Honor. And I understand how that police report, which is in the appendix, it can be read. And I'm sure the first time I read it probably the same way Your Honor read it, which is this is, not a good situation. You have a young man, albeit he is an adult, he's 18 years of age. He's in a house, he's shooting a BB gun at his neighbor, and the police come and say, "Why are you doing that?" And he says, "Well, I hate them." And then they ask him, "Are there any other guns in the house?"
It's a good argument
And he-
to have some restrictions on.
Well, and he says yes, and he leads them to the guns. The other way to look at that, it's kind of like looking at the other side of the moon question, I think, is, was he shooting the rifle? There was a rifle and a shotgun in his father's room in cases. There was ammunition for one of those guns, the rifle, in the father's bureau drawer. The son was not shooting the rifle at the neighbor. The son knew exactly where those guns were. He was an adult. They were in cases. They were not loaded.
So
He was shooting a BB gun.
And-
Do we jump to the presumption that because he knew where, and the BB guns are treated differently, I submit to the court, than firearms, which are handguns, and rifles and shotguns under our statutory scheme, Chapter 140, the civil licensing scheme, and Chapter 269, the criminal scheme. He was not shooting a rifle or a shotgun, nor is there any evidence in this case that he said he would or threatened to do that.
But what's the relevance of those facts to the constitutional
He-
issue, whether Heller bans all regulation? That's what you seem to be arguing. Bans all regulation of handguns in the home. Is that
For
you're
what
saying?
we know of this case, Judge, there was an adult family member in the home with the rifle, not a
But-
firearm.
But is your
And I
argument...
think, and I submit to you that Heller stands for the proposition, and I believe that the court very well may elucidate this in the McDonald case, which versus Chicago, which is going to be decided before June, that the state does not have a right to regulate, okay, to this extent, the possession of unloaded firearms, or even loaded firearms, perhaps, in the home for lawful purposes such as self-defense, unless there's some, using a scrutiny argument, compelling reason, such
Mr.
as
George,
if there
let
are
me
minors in the
Mr.
house.
George,
There weren't any minors in
Mr.
this
George,
house.
your time is up, but let me ask you this.
Yes, Your Honor.
Under
sorry.
this regulation, the Massachusetts, not the D.C. Circuit, is it your position that it is impossible for a citizen to use guns under our regulation for self-defense?
The answer is, I think it's dangerous. If you have to have the
No, no,
gun
no. Is
on-
it
on your hand,
impossible? Impossible is
close
not.
to it, for
No,
example.
no, no, no. I didn't like the opinion.
I understand, Your Honor.
Is it impossible for self-defense?
In the most likely circumstance, I submit to Your Honor it is, and I would just like to explain that for 1 second. If you have reason to be in fear of your life, you have to go to the door with a gun, and you've called the police are going to pull their guns too. Police see a gun, they pull a gun. It means that you have to have the gun on your person at all times if you are using it for self-defense, which in fact, as a reality, is not a very wise thing to do.
Thank you, Mr. George.
Thank you, Your Honor.